And in celebrity court news today, our very own international DJ Kandeke was convicted of the offense of nuisance by a drunken person by the Ndola Magistrate Court after making a guilty plea to the said offense. Now, I know I have been owing you part 2 of the court process, so we are now getting into it since celebrities are keeping us real busy with court things. Let's jump into it. In my last video, we talked about how and what arrest is and who can do all that stuff, and I did say that in this video, which is part 2, I will dive into what does the process look like. So the process starts at arrest, obviously, and now someone is brought before the court of law. What happens? So the first thing that happens is you will observe that counsel, if there's representation by counsel, will go on record. They will introduce themselves. This is where I'm from. This is who I am. After that, you will see that the court, the judge, but I think we're going to focus on the magistrate court. The judge will then read out the charge to the accused person. So you will see the accused person in the dock. At this point, they will be standing and the charge will be read to them. So we'll take the example of the Kandeke case because after the charge is read to them, the accused person, the person who was arrested in this case, will be asked if they understand the offense. And if they don't, it will be read to them and it will be explained to them in a language that they understand so that they know why they are at court. After this, then you'll find that the court will ask, how do you plead to this offense? This is called taking the plea. This is the part where the accused person or the person who is arrested has the opportunity to say whether they are guilty, they agree that they did this offense, or they are not guilty to the offense. The first instance is when they plead guilty. Like in the Kandeke case, the charge was read to him, and he said, yes, I did it. So he said he pleaded guilty to the offense. What happens then is the court will conclude the matter, say you have been found guilty of this offense, then mitigation will happen. So mitigation in simple terms is just simply asking the court for leniency, but obviously it should be within the limits of the law. So we'll do another video on mitigation because this one is short. So after mitigation, then within the power of the courts, they will then pass sentence. If you're going to get arrested, then you get arrested. Yeah, so we'll do another video on mitigation. That is one way. And then there's another way where someone then says, no, I am not guilty of the offense. There's a few things we need to understand about that. Remember, the standard of criminal law is that if the prosecution, the people who bring you to court, accuse you of an offense, they must prove their case beyond reasonable doubt. So if you say, no, I didn't do it, I'm pleading not guilty to the offense, now it's incumbent upon the prosecution to prove the case against you, because remember, you are innocent until proven guilty. In that case, the prosecution, now the people who brought you to court, will bring their witnesses, bring their evidence to now build a case against you. After the prosecution concludes its case against you, then we get to that case now that started all this fracas with these videos with Musiani. The court has to decide if they think you have a case to answer. So, case to answer stage, no, does not mean that you have been found guilty of the offense that you have been charged with. Case to answer just means that the evidence that the prosecution has presented before the court has given rise to them to hear your defense, to see if they should be passing a guilty or not guilty sentence. So case to answer stage is not a stage where the court is saying you are guilty. It is very possible for the court to put you on your defense and still find that someone is not guilty and they can walk free. It's just that the prosecution has made a case strong enough to compel the court to move forward to hear the case further. The next stage is now when it is said that the court has put the accused, the person who was arrested, on their defense. At this point, the accused person has the freedom to decide whether they want to give evidence on oath, which is always a better option because it sort of increases quote unquote credibility in the things you are going to say, or you can choose not to give evidence, not on oath, or you can choose to not give evidence at all, and you can just let the court decide. Whatever it is that you choose after that process where you to call witnesses, you bring your evidence and whatnot, the process is are followed. So a lot of the time people are curious. So when a witness is on a stand, you give evidence in chief first. So it's the first story of the person. Now, if a witness gives us their story, they say what happens. Then cross-examination follows when the opposing counsel will come and, ask questions to test the truth of what that witness has said. And then there's re-examination when your own lawyer now comes to kind of build that case again where it seemed like cross-examination had butchered your case. So that's about witnesses, because I find that a lot of people find interest in that, but we can do another session with just, examination, right? So once that process is done and you have called your witnesses and given your evidence, both sides, the case will be closed, and now the court will be given an opportunity to go and make a decision whether they find the accused person guilty or not guilty, and that is when they'll either be convicted or acquitted. So let's say the person who was accused, let's say for example in this Musiani case, we find that the court decides that he is guilty of the offense. Remember that situation with the plea situation where if he was found guilty, if like the way Kandeke had pleaded guilty and he was convicted, he was given an opportunity to mitigate. It's the same thing here now. If for instance, as an example, this is an example, I'm not saying he's been found guilty. If Musiani is found guilty by the court, he will then be given an opportunity to mitigate, to ask the court for leniency regarding his case. So after that, the court will then sentence within their powers, but that can be another conversation because the process is long. So that in a nutshell is the process. So after that, there's conviction, mitigation, then judgment. Okay, so conviction, mitigation, judgment. So this is a summary of the steps. You are arrested, the charge is read to you. After the charge is read to you, they are asked if you understand, and if you do, then they ask you how you plead. You can plead either guilty or not guilty. If you plead guilty, then the court will go ahead and convict you, ask for mitigation, and then pass judgment. If you plead not guilty, you will now go into what is called trial, where witnesses will be called and evidence will be tendered before court. The prosecution goes first, they bring their people, then the court gets to a place called case to answer and decide whether they should move forward with the case or not. If they put the accused on their defense, then the defense, who is the accused person, will also bring their evidence. After that, they will find whether there's a conviction or an acquittal. After that, that's when the accused will either be, if there is a conviction, they will then be given an opportunity to mitigate. After mitigation, then judgment will be passed, and then you also have, I think, 14 days in which to appeal if you're not happy. I hope this was helpful. Bye-bye.